We're going to get geeky today about procedure. That's right, Supreme Court procedure by which cases move through the system, because you've been asking on X and down below about what's going to happen with the Supreme Court granting cert or not in the cases of Bianchi, which deals with the Maryland quote-unquote assault weapon ban, and the Illinois cases of Harrell, Bevis, and so on, dealing with, of course, the assault weapon bans, of course, propaganda term, and the magazine bans out of the state of Illinois and the cities therein. So we're going to talk about what to cheer for now that we know the Supreme Court is going to consider whether or not to grant cert in one or more of these cases. This is a big deal. We're going to talk process for a moment. It's important to understand so you know what to look for as the smartest person in your room. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many Second Amendment related books, including Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. Big announcement coming out very soon about the next book, finishing it off as we speak. All right, folks, so we have a couple big weeks coming up because on May 16th, the United States Supreme Court is going to sit down in a room with no one else present but the justices themselves. And they're going to decide whether or not to grant cert in a series of Second Amendment cases, including the Bianchi case dealing with a quote-unquote assault weapon ban out of Maryland, and I believe as well the Harrell, the Bevis, the Naperville, and the other cases that are arising out of the state of Illinois, speaking to issues of quote-unquote assault weapon bans, which, as you know, is a political propaganda term for bans on ordinary semi-automatic rifles, as well as magazines that hold more than a certain number of rounds. Okay? So I want to talk about the process. Every legal case, remember, there's two general components to a legal case. And this is going to be a little geeky, but I think it will help you understand the process and know what to cheer for on May 16th and the weeks following. To begin with, every legal case has process and substance. Process and substance. The substance is what we spend most of our time talking about on this channel, dealing with the substance of the Second Amendment. What does the Second Amendment mean? How does it apply? How do you interpret it? How do you win with it? And so on and so on. That's the substance of the law. 4 elements of a contract. 4 elements of a contract, breach of contract case. 4 elements of a tort case. Whatever it is, those are substantive legal principles. What does it mean to commit a murder under the law? That question is addressed by substantive law. Now, there's another very important part to cases in American law. That is the process. It is the process by which a case, either a civil case, works its way through the court system, or a criminal case works its way through the court system. Now, I want to talk a little bit about the process of how the Supreme Court decides whether or not to grant cert, which means to hear a case. To begin with, Article 3 of the U.S. Constitution says that the Supreme Court has jurisdiction over cases and controversies. Now, the Supreme Court today, as a general matter, has complete discretion in almost all instances as to whether or not to hear a case. This was not always the case, but now it really is. There's a few instances where the Supreme Court must hear a case, such as if states are suing each other directly. Famous example of this is when the state of New Jersey sued the state of New York, and New York sued the state of New Jersey over who owned Ellis Island, because there was a fight about who owned it. That went directly to the Supreme Court with original jurisdiction, but those instances are very, very rare, which means the Supreme Court has basically complete discretion about what cases they hear at a given term. So on May 16th, the Supreme Court is going to be conferencing the case of Bianchi and these other quote-unquote assault weapon cases. And what does that mean exactly? Well, before the Supreme Court sits down, and by the conference it means the justices sit down together. There's no one else in the room, and they decide whether or not to hear a case. For the Supreme Court to grant cert, 4 justices must want to grant cert and vote to hear the case. If 4 justices vote to hear the case, the Supreme Court will hear the case. But of course, there may be instances where you would like to hear a case, but you're not sure if you're going to be able to win the case. So if you're a justice, you don't want to vote for a case that you're going to wind up losing if you're concerned about that. Let's say if you're worried about preserving affirmative action and you think you don't have 5 votes to preserve affirmative action, then you probably don't want to vote to grant cert because you know that the ultimate outcome on the merits will be bad for affirmative action, for example. So that is what's going to be discussed on May 16th. But here's the thing. We're not going to hear on May 16th or even the 17th or 18th if the Supreme Court decides to grant cert in these quote-unquote assault weapon cases. One of 2 things will happen. One is very bad, and one is neither good nor bad. If the Supreme Court certainly has the jurisdiction and the authority to deny cert. So if they conference the Bianchi cases on May 16th, which they're going to, and they decide they don't want to hear this case, they don't have 4 votes, it's clear they don't have 4 votes, they choose not to hear the case, no one wants to grant cert, let's say, well, they will issue a statement, an order, if you will, a few days after May 16th that says cert is denied in the Bianchi case, or cert is denied in the Bevis case, or cert is denied in Naperville, or cert is denied in Harrell, whatever it is. It will just say cert is denied in those cases, which means the Supreme Court has taken a look at the petitions, decided not to hear the case. Okay, so that is not what we want in these assault weapon cases because we want the Supreme Court to grant cert. These should be an easy case for us to win if the court just takes the case. So that's what we really want. Now, what we anticipate happening, or what I anticipate happening, what you should anticipate happening, is that on May 16th, they will conference this case, they will talk about this case amongst themselves, and then what we hope happens is that the case gets relisted. Now, what does relisting mean? What relisting means is, it can mean a couple different things, sometimes good, sometimes bad. It means that the court conferenced a particular case and then they've relisted the case, which means they're going to reconsider the case and whether or not to grant cert at the next private conference of the justices. Now, this can mean, usually it can mean one of 2 things. I guess in some ways it's one of 3 things. The first thing it can mean is that there's a real effort by one of the justices or some of the justices to try to get other justices on board to grant cert in that case, and more time is needed, so they basically have this case relisted. So if there's a fight about whether or not to get 4 justices, what are we going to do, and there's a debate about it, then rather than just deny cert at the May 16th conference, they could relist the case and continue to reconsider the case and think about the case to see if they can get 4 votes to grant cert. That's one possibility. The other possibility is that on May 16th, the Supreme Court has tentatively agreed to hear the Bianchi case or the Harrell case or the Bevis case or whatever. They've tentatively agreed to hear the case, but they don't want to announce it yet because they want to check the procedural posture of the case to make sure it's all perfect. And what do I mean by this? As you know, that as I've said before, the Roberts Court doesn't work, in my opinion, it doesn't work to take as many cases as they should. In the 1970s, for example, when the liberal judicial activists controlled the Supreme Court, you would see Supreme Court terms where they would hear 200, 250, 300 cases on the merits, and they would issue all these rulings about American law. Today, the current composition of the Supreme Court, the current Supreme Court, the Roberts Court, will only hear between 60 and 70 cases on the merits a year. Now, there's a lot of debate as to why this is the case. We don't need to get into this now. But the point is that because the Supreme Court is only hearing on the merits 60 to 70 to 80 cases a term now, every case they take is very, very precious. It's taken up precious court resources. So the reason why this is important is on, let's say, for example, on May 16th, they decide tentatively they want to hear the Bianchi case, but they want to check it out. And what that means is they will tentatively vote to grant cert on that date. They will then go back into their chambers and they will basically ask the law clerks involved in the case, is there any procedural problem with this case or anything weird about this case that we should know about that might make it really something we don't want to do, even though we've tentatively internally said we're going to take the case. What do I mean by that? I mean by that they will take a very close look to make sure that the plaintiffs have standing in the case, because if they don't have standing, that can be raised at any point. And if there's no standing, the court can't hear the case under Article 3 case and controversy provisions. So if there's no standing or a problem about standing, they don't want to spend a bunch of time on standing, so they might then change their mind and deny cert in the matter. Or maybe there's a question about mootness, meaning is the case moot? Is it still a live controversy? Has the law, for example, in Illinois been changed, or the law in Maryland been changed in some way to moot the case out? That's the sort of thing the Supreme Court will look to, just to see if there's any procedural or other issues with the plaintiffs or the case or the posture, anything that might cause, if they grant cert, to all of a sudden have to deal with other issues other than the specific question they want to deal with. In the Bianchi case, the Bevis case, the Harrell type cases, those will, of course, all be about the merits of the Second Amendment. They don't want to spend all their time dealing with like an issue of standing. So when they relist a case they intend to grant cert to, they will then spend a few weeks looking very carefully to make sure there's no previously undisclosed problem with the case, and if there is, then they might reconsider. And if there isn't, then they will go ahead and grant cert. But they will relist the case as they're conducting the due diligence on the matter. So the reality is it's very, very rare that they will ever grant cert publicly in a case. They will always relist that case, sometimes more than once. For example, the Dobbs case, which ultimately was the Supreme Court case that overturned Roe v. Wade, that was relisted, I think, well over a dozen times. It was kept getting relisted and relisted. I want to say it was relisted like 18 times. Don't quote me on that. But the Dobbs case was relisted many, many, many times as they were trying to figure out what they were going to do before they finally granted cert in the Dobbs case, which, of course, was the abortion decision that overturned Roe v. Wade. So again, what we want is on May 16th, the Supreme Court to relist the case and not deny it. Now, there is a possible bad outcome if the Supreme Court decides to relist the Bevis, Harrell, Bianchi cases, those Second Amendment cases. The potential bad outcome, if you see a case that keeps getting relisted after the initial conference, is the possibility that the Supreme Court has decided that they're going to deny cert in the matter. But one or more of the justices is unhappy about the denial of cert. They wanted to take the case, so they are allowed to write a dissent from the denial of cert. So the one thing we don't want to see, in my opinion, is that on May 16th, there is a decision to relist the Bianchi, Bevis, Harrell cases, assault weapon cases, and that gets relisted a period of like 5 or 6 times over a period of a month or 2 months, and then all of a sudden we see the denial of cert order come out, but then we see like a long dissenting opinion from Justice Alito or Justice Thomas or Justice Kavanaugh or someone saying, we should have taken this case. It's getting abused. The assault weapon issue, the semi-automatic rifle issue is getting abused in the lower courts. We should fix this. This is absurd. That is the last thing we want to see, is these cases get relisted a bunch of times, then they get denied cert, and then there's a dissent from cert. But sometimes if a case keeps getting relisted publicly, what's going on is someone is spending time writing a dissent. And again, a case could be relisted many times. It can be relisted really an infinite number of times as a practical matter, because again, the issue is whether or not they're going to grant cert. So the bottom line that kind of walks you through the process: once the case is distributed, there's a conference, and then they either will deny cert on the spot or they will possibly consider it. But whatever they do, our desire should be for the Supreme Court to relist the Bianchi, Harrell, Bevis case at least once or twice, and then grant cert. That is what we really want to see. So in a perfect world, we would want these cases dealing with semi-automatic rifle bans out of Maryland, Illinois to be granted cert, I would say somewhere between June 1 and June 10th of 2024. That would be about right, because they would relist the case for a week or two so that they could conduct the due diligence to make sure that there's no procedural problems with standing and mootness and whatnot. and then they grant cert. So what we're really cheering for is what happens in the first couple weeks of June 2024. That's when we should really start getting concerned if they have not yet granted cert. And of course, if they just deny cert, a day or two after May 16th, well, then we'll know the Supreme Court really wants the Seventh Circuit and or the Fourth Circuit to issue their rulings on a final judgment before they take up the issue of semi-automatic rifle bans. And I hope that's not the outcome, but statistically speaking, that probably will be the outcome simply because these are interlocutory appeals. And even though the Maryland case in Bianchi is a final judgment, the Fourth Circuit has heard argument en banc, and they're going to issue a ruling. So it's possible the Supreme Court may just want to wait for that, which I think would be unfortunate. But I'm not on the Supreme Court, and I don't control the Supreme Court, so we'll have to just wait and see what goes on. So anyway, and if you want to learn more about Supreme Court process, check out SCOTUS blog. It's a very good website, SCOTUS blog. You can learn about some of the geeky details about Supreme Court litigation if any of you are interested beyond Second Amendment cases and whatnot. All right, folks. Well, I hope you learned something here today at the Four Boxes Diner. Make sure you subscribe to this channel and resubscribe, trying to get to 150,000 subscribers just to keep growing the channel. Don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.